SJC-13816, Commonwealth versus Jose Arias.
Attorney Warren.
Good morning, and may it please the court, John Warren on behalf of Mr. Arias. We are asking that this court reverse the motion to suppress in this case. Under the touchstone of Article 14, what the police did here was not reasonable. It was not reasonable to use the traffic infraction from a full day earlier as a pretext to stop Mr. Arias. And it can't be the case that Mr. Arias' driving on Market Street was criminal and arrestable, where all he did was travel 1 block and attempt to turn left at the first available side street off of the congested Market Street.
What's the limiting principle? How long can the police wait to actually issue the traffic citation? Or actually to stop you for the traffic violation?
Right, so I think under De Vega, which adopted Mendonca, the federal case, it comes down to a balancing of the government interest versus the individual interest. And so here in Mendonca, it was 1 hour, and the court there said that was a lengthy delay and it was unreasonable. Here we have a full day. And on top of that, the stop was, like in Mendonca, the stop was pretextual. And what the courts in Mendonca and De Vega said is that where the stop is pretextual, that raises the individual's interest in being free from a stop that is pretextual. In other words, the police can't just take a traffic stop, put it in their back pocket, and pull it out whenever they decide that they want to make a pretextual stop.
If it hadn't been a pretextual stop, is there any other reason why this 1 day delay would have been unreasonable?
Yes, I do think that any sort of delay has the potential to be unreasonable based on the facts. And it could be the case that a stop isn't pretextual and there's a certain amount of delay and that it's nevertheless unreasonable. But I think when the stop is in fact...
I'm asking about this specific case, not about abstractions. In this case, your client drove in a area of the street that is not a travel lane for vehicles, for motor vehicles. Passed people on the right, and then turned left in front of them. It's a serious traffic violation. It's not like speeding 3 miles an hour above the speed limit. And so I'm wondering what would make a 1 day delay in stopping a person who committed that kind of traffic violation, assuming, as I think we have to, that the judge credited the officer's testimony that there was no safe way to effectuate a stop right at the moment. What made that stop unreasonable if we remove the element of pretext?
So, to Your Honor's point, the judge did not find that the Officer Peerway, couldn't have followed his normal practice, which was to call in a marked unit because he was undercover. The judge made no specific finding on that officer calling a marked unit to make the stop. And where it was the Commonwealth's burden at the hearing to establish that this was a reasonable stop.
We can make some, I think, conclusions about what the judge's findings, implicit findings were. But so I don't think that's your strongest point. Probably good, maybe you could answer my question, which is what would make this unreasonable apart from the fact that it was pretextual the next day? Do you just not have an answer to that?
No, it's unreasonable because the police had opportunities to make the stop, not only that day. I do think the judge didn't make any findings on that. The Officer Peerway was asked at the hearing, why did you not call for a marked unit? All he said was one word, safety, without any elaboration. That's a conclusion. The Commonwealth did not elicit the facts as to why he didn't make the stop right then and there. But then you go to the next day.
I think the question is really like in the abstract. If I'm a driver, I pull over into something that's not a travel lane. I make a left turn in front of all these people who are appropriately stopped. Is it okay for the police to come knocking 24 hours later? What makes that unreasonable if they're not doing it on a pretext?
So I think drivers would expect to have a traffic infraction dealt with right then and there. And to the extent that it's not, it's the Commonwealth's burden to sufficiently explain why there was a delay. And that simply didn't happen here. And it's not just Officer Peerway in the moment and an insufficient explanation as to why he didn't make the stop. It's then the next day Detective Feeney, who's working with Officer Peerway, is back at that address in Brighton, camped out again behind the vehicle.
So if Feeney made the stop the next time they saw him, according to the record, that would have been reasonable?
It would have been more reasonable than Officer Feeney watching him leave the address, walk to his car, and not go up to him and hand him the citation and deliver him the citation. And in fact,
How do we write this opinion? Let's just say we agree with you that there's some limiting principle. Just sort of the rule of reason, totality of the circumstances.
I think it's a
what you're
balancing,
suggesting?
right? So if you were to write the decision, a balancing of the government interest versus the individual interest. And here, where we have a full 1-day delay, where we have the fact that it was a pretextual stop and not even the real reason that they stopped Mr. Arias, and you have police opportunities before they actually effectuated the stop to deliver Mr. Arias the citation, which in fact they never actually gave him or wrote.
Importantly, on government interest balance, and the government interest has to do with the safety protections of the traffic infraction itself, correct?
Correct. And
How does that play out here?
Right.
well, here I think it plays out similarly to as it did in Mendonca, where the driver was going 90 miles per hour on the highway, was trailing other vehicles too closely, was changing lanes without signaling. The point is that if the traffic safety infraction is such that it needs to be addressed by the government, then the police should make the stop. And if they don't make the stop, they should come in and explain why it was reasonable to delay, and that simply didn't happen here.
Is this an exception you're proposing to the authorization rule, or is the authorization rule grounded in reasonableness under Article 14?
I would suggest it's the latter, Your Honor. And I think what's interesting about De Vega and Mendonca is that those cases take into account the nature of a stop being pretextual, because that goes to the government interest versus the individual interest in this balancing.
So when it's feigned government, when we're looking at the real government interest that they professed at the time of the stop, that's what's really going to diminish their governmental interests and safety concerns over the traffic violation.
Correct. And so this court, under De Vega and Mendonca, could decide this case without touching, whether pretextual stops are improper under Article 14 on the whole, because the idea of a pretext plays into the balancing between the government interest and the individual interest under Mendonca and De Vega.
But don't we usually judge the officer's conduct at this stage from an objective standard as opposed to a subjective standard about what their intent was?
Generally, I think that's true. However, I think under De Vega and Mendonca, it's clear that
Well, I mean, De Vega discussed Mendonca, but it is a different case, and it didn't. I don't think it didn't. It was dicta to the extent that it addressed this kind of situation with respect to Mendonca. It did repeat some of Mendonca, but it doesn't seem to me that it decided that in Massachusetts we take into account pretext.
Sure. I think to the extent it doesn't, then this court should take into account pretext insofar as it bears on the individual interest, as the court did in Mendonca.
Can you address a little bit the spectrum that we have? There's the Sixth Circuit case that's discussed in De Vega, where the officer knew that the person didn't have a license, or I think was driving without a license, and so it was what the Sixth Circuit referred to as a continuing violation, and there was a lot more justification to stop the person a day later, and then the far end of the other side of the spectrum is, of course, De Vega, where the violation was just literally blocking traffic that was completely resolved, this court noted, once they moved the person along. It seems to me that this falls in the middle category because it's a really dangerous maneuver that is reckless, and traffic citations have two purposes, right? In the moment, they potentially identify whether a person is drunk, whether, they stop trying to address the behavior at that moment, but they also have a deterrence purpose, do they not?
So I would suggest this is much more like De Vega and Mendonca, frankly, where it was a single maneuver. It was a one-time incident. Just like, Mendonca actually was arguably more continuous because it was over the extended period of time on the highway. But I think this is towards the De Vega spectrum, where it's a single incident, and it's not like someone getting behind the car again with an unlicensed.
But it's
without-
harder to say in this case that the government's interests in safety were completely lapsed. Is it not?
Well, I would say that they were, and to the extent they weren't, they should have addressed it in real time or explained at the motion to suppress why it was not addressed, sufficiently explain why it was not addressed in real time, or hand them the citation the next day before you have this individual, if you're so concerned about of traffic safety, before he gets back into the car again.
But where it's a reasonableness balancing, to win, you don't need to establish that there's zero government safety interest here, do you?
No, especially when it was not even the real reason for the stop.
So can you go back to Justice Wentland's rule, a question about what is the rule here that you're really asking this court to establish?
I think the rule is simply reasonableness and a balancing of a government interest, and where you have, balance the delay, look at the government interest in effectuating the traffic stop and the opportunity that the police had to address it prior to the point in which they did address it, and that's the balancing
So
test.
given what you've just said, does it make sense for your position to be that pretext matters?
Correct. Pretext does matter.
Why is that good for you? Why wouldn't you want to say, regardless of pretext, if it's too long a period of time, it's not reasonable?
Well, I think that goes to Justice Woldehogian's question, and I would agree with that a delay could be reasonable without pretext. I just think it matters. Because it goes to the government's actual interest in traffic safety and it not being the real reason that they actually even stopped this person.
So I'm a little bit confused. I thought a little while ago you said that the pretext was something that was part of the calculus of the individual's interests. So are you saying that under the governmental interests, you're also using that as part of the framework?
I think it goes to both, Your Honor.
Okay. So going back to the governmental interest, though, so if the rule is in at least gauging the governmental interest, that the viewpoint is a totality of those circumstances. So in that case, if there wasn't pretext and there was a hearing, and at that point the government introduced evidence as to why they had to wait the next day, or that it was reasonable to wait the next day, you could lose.
Correct. If the explanation was sufficient, I think that would go in their favor and we could lose.
Can I take you to the second issue? Which I'm very interested in, about how do we deal with the stop? How do we deal with the car moves slowly. The judge somehow finds it's an arrestable offense, but he doesn't make express findings about whether he could have pulled over. So, because if you win on that, again, we avoid a lot of the complicated pretextual issues, right?
Correct. There's 6 issues here. Any one of them would win the case for Mr. Arias.
Focus on that.
So with respect to the failure to stop, what happened here is Mr. Arias traveled slowly for about a block, a very short distance. Obviously, it's going to take some amount of time to realize that police are trying to stop someone and that you're the person being stopped. The judge, at the conclusion of the hearing, determined there was no space on the right-hand side of the road to pull over. Now, if Mr. Arias had stopped in the middle of the road, he would have blocked all the traffic on Market Street. And in fact, the RMV suggests that you're not supposed to stop in the middle of a travel lane. And so what Mr. Arias did was attempt to turn left at the first available side street, which was Bennett Street, to move out of the travel lane. And he at no point fled or sped off. He didn't try to evade. Once he was stopped by those cars heading the opposite direction, he didn't try to go around those cars or evade them.
He couldn't, right? He was boxed in at that.
He was blocked, but there was certainly no, attempt to evade those cars.
So so your view is the judge's finding that this was an arrestable offense is clearly erroneous on the facts, or what?
It's twofold. It's twofold, Your Honor. First of all, there was no probable cause of failure to stop. He didn't commit that offense based on the traffic situation that was going on. And I think the implications for all drivers, if this is probable cause for failure to stop, the implications are pretty problematic. That police could take a short delay where there's no really other reasonable place to pull over, and say that not only is that unreasonable, but actually that's a crime and that's arrestable, that simply can't be the case. So
They can exit order you and pat frisk you.
exit order, pat frisk, arrest, take you to the station, and charge you with a criminal offense. That simply cannot be the situation. And so the argument is really twofold. On the first hand of it, there's no probable cause to arrest. And on the second point of it, which is the Atwater issue, the arrest itself was unreasonable. And what I would suggest this court do is reject, as many other states have done, reject Atwater and consider the reasonableness of the arrest here, where on the one hand you have a full custodial arrest, someone being taken into custody, and on the other hand, you really don't have a breach of the peace based on Mr. Arias' driving.
Do we need a breach of the peace here? Because we have a statute that makes this arrestable, right?
Correct. So that's the Atwater question. Essentially, does there need to be an Article 14 reasonableness balancing, notwithstanding the statute? And what I would ask this court to do is to reject the conclusion in Atwater, and to do that reasonableness balancing, and to consider whether there has been a breach of the peace. And here, Mr. Arias didn't do anything to breach the peace. His driving was de minimis. To the extent there was any effect on the public, that was inherent in police making a traffic stop with numerous cars and officers disrupting traffic. And I think with respect to Atwater, if this court follows the logic of the Atwater case, that this court gets to the opposite conclusion, because in Lunn, this court determined that under our common law here in Massachusetts, we require a breach of the peace to make an arrest for a misdemeanor. So
Can you just address the Commonwealth's argument that the failure to stop itself, I understand that you don't agree that there was a failure to stop, but assuming that there was, that failure to stop was a breach of the peace?
So I would suggest it wasn't. Breach of the peace is having some disturbing effect on the public. Mr. Arias is driving. He traveled slowly for 1 block and attempted a left-hand turn. That's what his conduct actually was. That didn't have any effect on the public.
Doesn't the record, it had some effect, right? Like all of traffic in that location had to be snarled up so that the police could address. I understand your argument that what he did was not reasonable and that this was not a really lengthy failure to stop. But as a matter of fact, police had to, in their view, execute a maneuver where they completely blocked traffic by Forest Hills and all the cars are piled up such that he couldn't, there was a whole snarling of the traffic that occurred. So I think it depends on how much of a breach of the peace counts as a breach of the peace.
So that the effects of him being stopped on a busy, congested 1-lane road were inherent in police stopping someone on a busy, congested 1-lane road. In other words, when you look at his actual conduct, I think you have to look at what he did. He traveled for a block and attempted a left-hand turn, and that didn't cause a breach of the peace.
And you think that it has to be specific to the particular defendant's conduct in any particular case and not a general rule with respect to failure to stop? Because obviously there are numerous circumstances in which it creates a huge public safety hazard if a defendant refuses to stop.
Absolutely, absolutely. It's what I would suggest is there needs to be an Article 14 reasonableness balancing of the arrest itself.
So in every single case, police officers have to decide whether there's a breach of the peace before they can make an arrest for a misdemeanor.
More broadly, just that the arrest is reasonable in the circumstances. And I think it's noteworthy here that Mr. Arias was never even charged or cited with failure to stop. This was a theory that the Commonwealth conjured up prior to the suppression hearing. And it goes to the fact that, to Your Honor's point, if the arrest is reasonable in the circumstances, then that's fine. But I do think there needs to be a reasonableness calculus where what we have here is someone driving a block, attempting a left-hand turn. We're going to arrest this person and take them to court and charge them with a criminal offense.
Well, they strictly speaking didn't arrest him here for that because they found drugs, and that is why they arrested him.
Right. Well, that's even worse because and that goes to the final issue for suppression being pretextual arrests, which is, are we going to be okay under Article 14 with arresting someone when it's not the real reason that they're being arrested. And here it wasn't even pretextual, it was a post hoc rationalization where the Commonwealth came into the suppression hearing and said, well, this was enough here for failure to stop.
Okay, thank you so much.
Thank you, Your Honors.
Attorney Hartley.
Good morning, and may it please the court. Brooke Hartley for the Commonwealth, and with me is Assistant District Attorney Thomas Laverty, who was the trial prosecutor on this matter, but not the motion to suppress prosecutor. Turning to the first issue, the motion to suppress was properly allowed where there was a reasonable one-day delay in initiating the traffic stop. So de Vega stands for the proposition that a stop must end when an officer observes a traffic violation but unreasonably delays initiating that stop on the basis of the violation. So the question here is, was the delay reasonable? And that begs the question, how do we define reasonableness? It's not based on the length of the delay.
Well, that's got to be somewhat, that's got to be a factor, right? Because if it's a really serious traffic offense and the Commonwealth thinks it, aren't they going to respond and get this guy off the road so he's not doing this again? So they can't just bank this for a month or...
So maybe I should rephrase it. It's not solely based on the length of the delay.
Sure.
That might factor into the reason for the issue. The question, the pertinent question is, what was the reason for the delay, I think, here? And could the officers have addressed that traffic violation and attended to the safety concerns previously? The answer here, based on the record we have and the judge's findings, is no.
Well, it's muddled, right? He's asked one question, why didn't you do anything? And he says safety. But that doesn't really make that much sense. He could, if he were really troubled by this, he could have said, I've just observed so-and-so doing this dangerous maneuver, pull him over and stop him. But that's not what, he's not bothered enough to do that. Right?
I agree, Your Honor. The record is sparse on this point, to say the least.
Well, isn't it more than because when Feeney gets them the next day, what the police say is we're conducting surveillance, correct?
Correct.
So the surveillance means, in this context, they're looking to see if he's dealing drugs during this point in time, right?
So
that's what's going on for real.
So we know there's a drug investigation,
Right.
Aside from the fact that that's an ongoing investigation.
So surveillance means watching. It doesn't mean stopping, correct?
Correct. But I think those are two separate issues here. I don't
Well,
think...
if the very first time they see him when he's getting into the vehicle, they decide to conduct surveillance to see what's going on, to see what's up, correct?
Correct.
And it's not just, oh, here's that traffic violator, pull him.
You mean the second day on the 28th when they... Yes, but so I think that the argument that Feeney could have stopped him when he first saw him falls short here. First of all, there's nothing in the record to indicate, yes, there was this drug investigation going on. We don't know anything more about it than that. That's not part of the record. But there's nothing in the record to indicate that Feeney knew anything about the traffic violation. And I think they're two entirely separate issues here.
So I had a question about that. Did Feeney talk to Pirouet that second day?
So he radioed when he saw defendant get into the car, what he saw, and he followed him for a brief period of time, then lost him.
But he radios, stop him for a drug violation.
Right. So that's the communication the second day.
So the communication from Feeney to Pirouet is what?
Is that I observed this individual in this location.
And Pirouet doesn't say in response, oh, pull him over because he did a traffic violation the day before.
No, but what he does at that point when he's radioed, Feeney says that I've lost sight of him. So Pirouet immediately goes to that location. Once he has eyes on the defendant, he then radios for backup to stop him because he's in an unmarked car. So the Commonwealth's position is that the stop, in terms of the traffic violation, was effectuated as soon as reasonably possible.
Well, what about, can you go back to the first day? Because I think there's a little bit more evidence that's relevant here. There's testimony from Pirouet that not only that this is explanation of safety for not calling a marked unit, but then eventually when pressed, he says, essentially that he decided not to stop the defendant at that point. And my question for you is, by a little bit by analogy to De Vega, was the traffic safety issue in that moment essentially resolved in a way that the testimony is that he decided, the officer who was the only officer who could cite him, because this is the officer who saw the traffic violation, decided not, the record reflects he decided not to stop him that day. And so why does that not resolve the traffic violation in the same, in an analogous, albeit slightly different way than what occurred in DeVega?
So I think first, because the reason, my reading of the record, the reason that he decided not to stop him was because of safety. He couldn't because of safety.
What is the reason why that is supported by the record or even just common sense that safety precluded calling in a marked unit at that point when it's his usual practice, which was his
So we
testimony?
don't have any testimony on that, but I think to the
And
extent,
it's the Commonwealth's burden, right? So
yes, but I think to the extent that the officer credited his testimony, which was it was not safe for us to stop him at that time, certainly more detail would have been helpful to the Commonwealth. But to the extent that the officer credited that, I think that's sufficient. And I think this is distinguishable from DeVega, where the court specifically talked about that violation, which was the car was parked in a street in such a way that traffic could not pass. So once the car was moved, there was no question that that was resolved. The question of reckless driving is different, and DeVega even says that this was not reckless driving. They also use the example of driving without a license.
Doesn't safety go say the exact opposite? If you're concerned about safety, you stop him. Safety has, how do you interpret the statement safety to support not stopping him? I have trouble with that.
So again, more testimony on this certainly would have been helpful, but my reading of safety was it was not safe for the police at that time. Not necessarily there was a public safety issue, which
safe for to say, officers pull him over, he's been driving recklessly.
because of the traffic pattern. I mean, I'm speculating here because the record is
that a problem?
sparse.
Is a problem. And the word safety, you have it doing a lot of work here that the record doesn't necessarily support. But I want to go back to something you just said a little while ago. I think to Justice Wendland's question about not knowing what Peerway's practice was. Doesn't it cut against the Commonwealth that Peerway did exactly what we're all wondering why he didn't do the night before? He called the black and white, right? The next day?
I'm not sure I follow you.
The next day, when he went to the scene and saw,
Oh, he called back up and yeah.
right?
Well,
So if he was concerned about safety, even if I give the loaded definition of safety you're giving, that he's undercover, maybe doesn't want to blow his cover, he could have called the black and white the night before.
Your Honor, and I'm not sure I'm speculating that much about what he was undercover and he wanted to blow his cover. The testimony in the way that he says it wasn't safe, I think has to do with the traffic pattern, and he just simply couldn't follow him in a safe way. Again, certainly more testimony would have been helpful, but I think to the extent that the judge credited that it wasn't safe for us to stop him at that time, that is a sufficient reason for the delay. And the next day when he saw him, he effectuated the stop as soon as reasonably possible. We don't have any testimony as to what the difference was on that day, why it was safe then and why it wasn't safe the day before.
Well, we do. We have his statement that there's a drug investigation, and so that's why I'm going to ask you to pull him over.
Well, but I think that's separate from the issue of why he didn't stop him the first day. And
But it's
also
indicative of why he stopped him the second day.
So, I mean, there's no question it's a pretextual stop. On both days, the stop would have been, he was following him for 6 miles, observed a serious traffic violation, and then would have, if he could have, stopped him at that point. But the pretext issue is separate. And the reason for the delay, based on this record, again, although more testimony certainly would have been helpful, is not because it has nothing to do with the pretext.
Do you agree that the pretextual nature of the stop goes to the governmental interest?
So I don't think so. I think that
All right, so let's break it down. The governmental interest has to be in the government's interest in enforcing the traffic laws, correct?
correct.
Wouldn't the pretextual nature of the stop, meaning the real reason we stopped this vehicle, go towards that governmental interest?
So I think I don't think that's part of the consideration when you have a lawful traffic violation, that the police are well within their rights, as this court has said and the Supreme Court has said, to stop that individual. Now, there is this case illustrates that there is a limit to pretext.
Okay, and the limit is the constitutional consideration of reasonableness, right?
Yes, and that, you know,
So when we said in DeVega, if this isn't bottomless authority, you couldn't stop him 15 months ago. You could stop.
Exactly.
A 15-minute delay is different than a 15-month delay. Right?
a pretextual, a traffic violation can't hang over someone's head infinitely. Again,
Well, actually, it can't really hang out over its head very long at all, because under the anti-fix statute, someone cannot be cited unless it's given at the time and place of the violation, unless an exception applies, correct?
that's true as well.
So how can you, so the legislature has said that the government's interests, and I understand that their view is not necessarily exactly the same as Article 14, but the legislature has provided that no one can get a traffic citation unless it's given at the time and place, unless very specific criteria are met.
Right.
So can you address how that relates to the government safety interest here? It suggests that it's limited in time.
It's limited in time, but there are exceptions, and I think those exceptions are similar to what we have here based on what the reason was for the delay. And so if the reason, like in Minnetonka, was that police observed this traffic violation, were sitting on it, this was very clear in the record. They had information that this individual had been seen near a motel before and stopped, had drugs on his person. They observed the traffic violation, observed him park in a motel, go in, come out, and then chose to stop him. And the court found that the reason that delay, 1 hour delay, was improper and rendered the pretextual stop illegal was because of the fact that police were attempting to gather more information. They were still conducting surveillance after this traffic violation.
But isn't that exactly what's happening here? I mean, I guess I'm wondering how this case is very different than that one, other than the delay is 23 hours longer.
So I don't think that's what's happening here. And I think that's because of, so again, there's an drug investigation going on separate and apart from this.
Right, and so when Feeney sees him the next day, he's surveilling him, just like they were surveilling the defendant in Mendonca.
But so Piraway, who observed the traffic violation, loses sight of him, does not continue surveillance on him, and stops him at the next available time that he's able to. So I think that's the distinguishing factor.
Is the record silent as to whether or not Feeney knew about the traffic violation?
There's nothing in the record about whether or not he knew about it. So I don't think we should.
Would that make a difference?
What's that?
Would that make a difference?
If he knew about it, I think it would probably make a difference.
If he didn't know about it?
My reading of the record is he doesn't know about it.
Well, I asked you if it was silent. You said it was. So
there is, but I don't think we can read into the record that he does know, where there's nothing in the record to suggest that he does know, I guess is my.
How does that cut for you? Because if it's a serious traffic violation and Feeney and Piraway are working together on the drug investigation, right? Maybe you would think he'd say, oh, I just saw him do a serious traffic thing too.
This is anti-collective knowledge.
Yeah.
Well, so I think Privet says that they have to be working together, working together in the same investigation, which they are in terms of the drug investigation. But again, I think the traffic violation is separate, and there's nothing in the record to suggest that he had told him about it or that they were working together to effectuate.
It would have been your burden to establish that he didn't know, correct?
To establish that he didn't know. It's the Commonwealth's burden at the hearing, but where there's no testimony that he knew, I think, and the judge had all of this.
There's no testimony that he didn't know either.
There's no testimony that he didn't.
So if you have the burden to establish the point, then doesn't that leave you in a tight spot?
Certainly would have been helpful if we had more testimony, if the record, again, had more, not only about this, but about the reasons for the delay in the stop. But I think that the judge was entitled, based on the record and the testimony, to find that the reason was it wasn't safe, and that this was Officer Piraway's traffic stop, and they didn't share collective knowledge, because there's nothing to suggest that they were working on this traffic stop investigation together, although there was this ongoing drug investigation.
Can I get you to address the second issue? So we got a busy street. They putter along for another, how long? 300, I can't remember. It's a couple.
A block, yeah.
And turn off to the side street. Really? You know.
So I think again, here, the length of how long it took him to pull over is relevant, but not the only deciding factor. If you look at the testimony at the hearing, not only did he fail to stop for a distance of 1 block, but he attempted to continue driving and turn onto another street. Now, I disagree
Was there
with...
somewhere he could have gone beside? I mean, where was he to stop on? I know your view is he should have stopped on the busy street, but that would have, again, created the traffic snarl that
It inevitably did happen in the end. But I would just say that and again, I understand it's the Commonwealth's burden, but the judge disagreed with the prosecutor's argument that he could have pulled over in an open space. There was no evidence of whether there was open spaces at that time, but he didn't explicitly find that there were no open spaces or nowhere to pull over.
But finding this to be, and again, you know, what this opens up is, you know, anytime you don't stop immediately, the cops can exit you and pat frisk you. Is that, that's troubling, right? And I feel like we're dramatically expanding what we can do for pretextual stops too, based on your interpretation. So go ahead.
I don't think so, Your Honor. And I think maybe the defendant and I disagree about what the facts were at the hearing and how that, whether or not.
Well, I mean, the facts were, I think, and you correct me if I'm wrong, stops or drives a block, slows down, like at a crawl, basically, and then tries to turn left, but doesn't accomplish that mission.
Mm-hmm. And I think
there's a rejection of the prosecutor's argument that there may have been spots to pull over on the right.
There's nothing.
Nowhere to pull over on the right. Next block down is a left turn, and he tries to turn left. I mean, that then anybody gets arrested for that?
And frisked?
So I think the testimony is what Your Honor said, but the officer's exact words were, first of all, there's a vehicle behind him with lights and sirens on, right? The testimony is it's right behind the vehicle. He attempted to continue driving and turn onto another street. He stopped only when the flow of traffic prevented him from turning. And at that point, police got out of the vehicle to stop him. The officer says when it became apparent that the marked vehicle was behind defendant's vehicle, he attempted to make a left onto Bennett Street. To make a 90-degree angle turn, all of the vehicles in the oncoming traffic lanes stopped. He wasn't able to make this turn. I think that testimony makes it more than just he was pulling over, he was turning at the next available street. And I also would remind the court that I think the way the defendant frames this issue is almost that it's a sufficiency issue after trial. This is a probable cause standard, which is obviously different than beyond a reasonable doubt. And I think that there is enough here. I don't think that this renders any person who is searching for a place to slow down safely, to pull over.
Hold on, but the probable cause, they frisk him. They can frisk him based on probable cause, or don't they have to?
Well, it's an arrestable offense, so yes. Yes.
So that saved him, right? I mean, that saved the whole thing, because had he pulled over in the middle of the street, there would have been no reason to make the exit order.
Yes, I think if this weren't a failure to stop, there would have been no reason to make the exit order.
Assuming it was a failure to stop was the reason that.
Yes, unless something else happened. Yes, I agree with that, Your Honor. If there are no further questions, Commonwealth rests on its brief. Thank you.